Well, it's always toughest being the last person on a panel, and you're listening to the presenter before you go forward and lay out the major issues you thought you were going to talk about. So I'll do a little bit of reshuffling as we go forward, but first a little disclaimer. Although this panel is denominated as the judicial perspective, I have to give this disclaimer. I'm not a judge. I'm a critic of judges, but I'm not a judge. But nonetheless, I do play a role that somewhat gets into that area. In most water rights litigation, it starts with an administrative hearing before the relevant department, in this case, the Department of Water Resources in Idaho. And we have either the director or some staff member that serves as a hearing officer in these cases. And in many ways performs the same functions that occur before the district court, in the sense that the director goes forward, receives evidence from the various parties that are involved in the particular dispute, and makes rulings with regard to the evidence that would be considered as part of his or her decision with regard to the matter before him. And so in that role, my capacity is as an advisor to the director or to the hearing officer, in which we assist them in looking at the type of evidence that's being presented and evaluate the credibility of that evidence in terms of support for the decision to be made. So it's that context that I'm going to speak to today, primarily as the administrative hearing process. And I'm going to look at three different aspects of that administrative process. One, I want to talk just quickly about some of the different uses of ET modeling, remote sensing ET modeling in the administrative process before the department. Second, a little bit about legal considerations in the use of models in that process. And finally, and this is the part I'll just skim over quickly, is some evidentiary considerations in that respect. But first, turning to water administration, there's basically three different contexts in which we look at that. We've dealt with it in terms of the Snake River Basin adjudication, and Judge Wildman has done a good job of describing that process. We also have done it through water delivery call proceedings, and those are the ones that Judge Wildman was summarizing that had gone through the district court and up onto the Idaho Supreme Court. But I'll talk a little bit more about them in terms of how that information came in. And then in water compliance and water planning are a couple of other areas that we use this data. Turning first to the water administration side of it, and the water delivery calls, typically the remote sensing data is used to, as Judge Wildman identified, ascertain the amount of need for a particular water right. One of the common misperceptions about Western water law is we tend to focus on just one element, which is first in time, first in right. But another kind of key component of the prior appropriation doctrine is that your right to divert water. You have a right to divert up to the full amount of the decree, provided that you're putting it to beneficial use. And so on any given day, you may or may not need the full amount of water under that particular water right. And so the first thing the director needs to do in a water delivery setting is to determine whether the proposed delivery call is coming forward, the amount of water that's being claimed or entitlement is being requested represents the extent of beneficial use under that particular right. And in many ways, the ET data has been very helpful in providing a way to quickly ascertain or get an overview of that extent of beneficial use. But a key is that it's one tool in that process because, as I'll discuss a little bit later, a model is simply a replication or a representation of an overall larger hydrologic system. It's not actual hard evidence, but rather a simulation of that evidence. And so then there becomes questions about to what extent can you rely on ET as an actual representation of the extent of beneficial use. We've used remote sensing ET data as well in terms of looking at mitigation plans. As we're moving through the water delivery calls and coming to the conclusion of those, what typically happens is the junior water user will come forward and provide an alternative water supply to mitigate for the impact caused by the junior depletions. One of the ways that has occurred in Idaho is through conversion from groundwater diversions to surface water diversions. So what would happen is, rather than diverting from the groundwater, an alternative surface water supply is found, delivered to the lands, and then there's an offset, and the offset in the amount of depletions that are occurring both from the groundwater and in terms of return flows to the system itself. And so what happens in that instance is we would use this remote sensing data to evaluate the extent to which curtailment has occurred on particular lands that are being idled, or to the extent that the beneficial use that's occurring on that lands, to validate whether the claimed activities that have gone forward have actually occurred. Another likely future use of this, because we're just now coming to the conclusion of the delivery calls themselves, is if we get in a situation of curtailment. In Idaho, and particularly the area where we have the greatest agricultural uses in the upper Snake River Basin, we have about 2 million acres, a little over 2 million acres of irrigated agriculture in the upper Snake River Basin. And as you can imagine, with most states, we've been experiencing the same kind of budget shortfalls that nationally have been going forward, and reduction in staff and workforce in order to implement more and more programs. So in doing so, absent having field resources available, some of these tools like remote sensing ET become a critical tool from an enforcement perspective, because it allows the agency to look out and evaluate from the data that's coming in from the satellites to the extent that the curtailments are will be implemented. So I suspect that will be a future use that we have with it. Similar to that, and an application we have been making a fair amount of use of recently, is water right compliance. It might come as a surprise to you that water users might divert in excess of the amount of water they're entitled. We find that on a fairly frequent occasion, and the way we typically do that is through looking at remote sensing data. And by looking at that data, it can identify where it appears someone is diverting in excess of the amount of water they're entitled, or irrigating acres for which they're not entitled to irrigate. And it's that data that then allows the department to move forward and concentrate its on-the-ground resources on those areas where it appears we have true conflict. The second area that we use it in, as opposed to just the enforcement side of it, is the water management side. I'm sure that you've had a large number of discussions about the Eastern Snake Plain Aquifer model. And that model is what we use to administer rights and to develop planning processes for the Eastern Snake Plain. And through that model, one of the things we need to know is the extent of consumptive use. And so the metric model that the department has developed has been linked to that ESPAM model in a way that helps us to take that evaluation into account in the model results, in running curtailment scenarios and other kinds of management uses that we have for the ESPAM model. The final area that we use this remote sensing data in is in water planning. Water planning is becoming very critical in the state. We have been fortunate to have an ample water supply until the more recent years, and now that we're beginning to see more and more pressure on the demands for the water from the Snake River, we're engaging ourselves in much more comprehensive planning. The triggering event for that is actually the event that was the start of my career in the Attorney General's office some 30 years ago. My third day in the office, I was assigned what's called the Swan Falls water right conflict. Briefly, what that conflict centers on is a hydroelectric dam that was created in the early 1900s down on the Snake River just south of here, south of Kuna. And with that water right, it was developed to take the entire flow of the river during that time of year. And so the water right was developed to 8,400 CFS, but it didn't contain any clauses in it to say that how that water right should be administered versus future upstream uses. Well, as often happens in water right issues, they don't come to fruition until many years later. And that's exactly what happened in this situation, is that as we move forward to develop in the Upper Snake Plain, the original plan was to simply use the surface water, but in the mid-1950s and 60s, we gained technology that allowed us to access the Eastern Snake Plain aquifer, which at that time was a primary, and it still is, the primary water supply to the lower Snake River below Milner Dam. Historically, in the area called Thousand Springs, the flows were in the neighborhood of around 4,000 CFS. Through upstream irrigation development, we developed the water supplies to the extent of surface water development, that we increased the aquifer level in the Eastern Snake Plain aquifer by about 60 feet over an 11,000 square mile area, which caused those flows in the Thousand Springs reach to go from the 4,000 historic level of 4,000 CFS to almost I think it was about 6,800 CFS. So that's a huge change in flow. And because of that change in flow, there had never been really a conflict between hydropower use and upstream consumptive uses. But with the advent of the pumping technology, combined with reductions in the amount of diversions under gravity irrigation as a result of increased technology and drought conditions, what we've seen are the flows in the Thousand Springs declining from that historic high of 6,800 CFS to where we're now down to around 5,200 CFS flows. And obviously, as those flows decreased, that impacted those water users that were located below the springs, specifically hatchery producers, as well as hydropower water rights. And that's what led to the Swan Falls conflict, because as the power rights were being diminished, the power company decided to go forward and build a coal-fired plant, which ran into environmental opposition and ultimately a ratepayer action before the Public Utility Commission, arguing that the hydropower company should not be able to rate base the Swan Falls plant because it had failed to protect those water rights. And that led to this large-scale conflict and ultimately the Snake River Basin adjudication. The reason I spent a little bit of time talking about it is that context is really interesting in light of where we're at today technologically. Back when I received the Swan Falls case, Norm Young, here in the back room, was the administrator at the time, and we were trying to sort out, well, what was the impact of groundwater pumping on the spring flows, and is it realistic to expect that that should be counted against those hydropower water rights? The way we did our work back then was with Mylars. Anybody remember what Mylars look like? Little plastic things you put on a screen, and spreadsheets. And today, using that kind of, going back and looking at that data, and I've been doing that recently because of some of the conflicts we're in, it's amazing to me how difficult it was to make decisions and how difficult it was to convince courts about what how this hydrologic system functions. What the remote sensing ET and the ESPAM models have done for us have really simplified to a great degree the ability to present that information, but at the same time complicated the problem because there are so many different assumptions that go into the modeling process that then the question becomes how representative of the actual hydrologic system is the model? Is it a fair representation? Can we rely upon the assumptions that are in it? And so from a legal perspective, it's complicated the presentation, it simplified the presentation of the conclusion in the case, but complicated the ability to convince the court of the appropriateness of reliance on that particular type of data. In a water planning process, we don't have to go through all those kind of issues. Instead, water planning is something where we're looking at reasonable predictions. And so from that perspective, the water planning aspect of this has been easier to apply, except when we get into the mitigation kind of conclusions. In any event, as I look forward in the water planning side of it, and I look at where we've been with it as far as developing the information necessary to resolve the Swan Falls conflict, one of the things we're doing today now is going forward and implementing the settlement that we reached in the Swan Falls conflict. And that basically requires us to protect flows at the Murphy gauge to 3,900 CFS in the summer and 5,600 CFS during the non-irrigation season. And one of the key issues on that is, can we effectively, through the prior appropriation doctrine, really preserve and protect those flows? Because from a regulatory standpoint, curtailing groundwater isn't going to result in immediate benefits to the lower river. And so what are we looking at, or how are we thinking about trying to address that problem of avoiding the need for water administration through curtailment, instead looking at it from a planning or a management perspective? And in that regard, it seems to me that the remote sensing ET and the ESPAM are going to be our key tools, because what we need to be able to do is to look into the future and see what the trends are. One of the things that the ET data allows us to do is to observe what those trends are. For instance, we now know, going back and looking back historically, that the changes from gravity irrigation to sprinkler irrigation had a huge impact, but we couldn't quantify it. But with the ET kind of data that we have today, now we can kind of start seeing those trends develop. And by being able to see them in advance, or see them as they're developing, allows us to do planning for the future. So again, quickly, the three areas that we really use it in are water administration, water management, and water planning. Okay, if that's the case, then what are some of the legal considerations that we take into account when using this kind of information? To me, one of the most fascinating areas from an attorney's perspective is the relationship between science and law. And it's not always a comfortable fit. And it's because we come at the issues from a different perspective. From a science perspective, what you're looking at is you're making observations about what's going on in the hydrologic system. You're testing hypotheses about why those observations are coming out the way they are. And science is fundamentally an iterative process where you keep learning from what you had in the past and building on that, and it's always an evolving process. And so you're searching to get more and more refinement or definition in the conclusions that you have. And I know just in the years that I've had in this practice, what we understand about the system today is light years compared to what we understood back when we were making decisions in the 1970s and earlier on how to manage the system. But contrast that with what we're trying to do when we're doing an adjudication, or when we're in an administrative forum trying to decide who gets what portion of the water supply. In the legal context, what we're trying to do is to give a definite resolution as between conflicting uses of water. And what's desired is a degree of certainty that is inconsistent with the level of science or understanding that we have. And so it creates this problem as we make our decisions, making sure that those decisions don't go too far into the future, because if we do, we may make a ruling that's going to have an impact on the ability to address what new science tells us. And one of the places that's playing out right now is in some of these subsequent proceedings on the delivery calls. The initial delivery calls were decided with ESPAM version 1 or 1.0. And since we've completed those initial delivery call proceedings, which started in about 2005 and are now through the court, just in that period of time, we're now into ESPAM version 2.1. We've gone past 2.0 into 2.1. And the evolution of the data and the knowledge that we have of the system is so much further advanced that now the challenge is how do you take into account the newer information in light of the past decisions you made under the prior delivery calls? How does that work with regard to the principles of stare decisis and finality? And we don't know the answer to that question yet, but it's certainly going to play out over the course of the next few years. That tension between science and law is a good example of that, of how it played out was with one of the delivery calls dealing with what we call Blue Lakes Trout Farm. Blue Lakes Trout Farm is located immediately below the Prime Bridge as it goes into Twin Falls, which is in the central part of the state of Idaho. In that, as Judge Wildman referenced, in that initial case, there was a determination made that we would need to have 10 CFS of water. The initial decision from the director was that we needed 10 CFS of water in order for the juniors to mitigate for the impact that they were having on this trout farm. Order came out. It was looking at like there was going to have to be a curtailment of more than 50,000 acres of land. And so the solution was to go out and to acquire the adjoining fish farm, the pristine fish farm, which diverts from the same facilities. The groundwater users acquired a portion of that water right and delivered it to the Blue Lakes trout farm. Almost as soon as that deal had been put together and the 10 CFS had been delivered, the director's next order came out on the Blue Lakes trout farm that indicated that no, what we needed, I believe, was around another 3 CFS of water to mitigate for that impact. Well, you can imagine after the groundwater users had expended $11 million to acquire 10 CFS, that they're now going to be subject to further additional delivery calls. Their warm feelings towards the director, shall I say. And that may be a bit of an understatement. Nonetheless, I think it demonstrates the complications that we have as we bring science to the table. We use the best available science today, but tomorrow it may be different. And so that's going to be an ongoing tension that we have to deal with in the context of all of these various water delivery calls as the water supplies become shorter. The other thing that we worry about is combat science. The stakes are high in this kind of litigation, and there are a lot of experts that have been hired. And it's surprising, you know, we all think of science as being this kind of homogeneous, uniform, brotherly love kind of situation where everybody reaches the same conclusion. Well, I'm here to tell you that's not the case. We have as many competing, you know, there's always been a criticism of lawyers, and maybe this is my good chance to get one in on the engineers, but criticism that lawyers can argue out of both sides of their mouth. Well, I've seen that also from the technical side of the house. I think that's a uniform hazard in the business. But nonetheless, that then raises questions that we have.
You have.
Does that work?
Okay, we'll try it again here. So anyway, so when we're looking at it from an administrative hearing process, one of the things that we're very concerned about is making sure that we've evaluated all of the assumptions that have gone into the model. And we also try to make sure that we look at the model in the way it's intended. Models are best used, at least from my experience, are best used as a way to measure change. The change from one expected pattern to another expected pattern, other than looking at the absolute values that are generated from the model itself. So in the context of the surface and groundwater system, we're looking at what are the assumptions that are being made, what kind of variability has been accounted for in the modeling process, and what kind of empiric evidence is there to support those conclusions. In the end, what ends up happening in the administrative process, though, is you have to use your best scientific judgment to say of the competing models, of the competing data that you're looking at, what has the strongest support for it, and then that becomes the basis for deciding which way to adopt or which model to follow, and then to apply the assumptions that go along with that. But these are complex cases. What we found, and I think I'll just skip over the idea of, or some of the evidentiary issues and come to what I think is a better approach to resolving these issues, and one that I have to commend the department for doing, and that is, rather than looking at these as separate independent decisions coming forward, to open up its modeling process. And that's what we did with the eSPAN modeling, is we have a modeling committee that has representatives from the various water user community interests on that committee that participate along with the department, the USGS, and we've essentially invited all of the best technical minds together to collaboratively develop a model that then forms the framework for our administration. And I think the truth and the benefit of that process has been demonstrated by the speed with which we've been able to move through these delivery calls. Typically, these delivery calls take tens and 20s of years to resolve. We've been through 3 major different types. The Clear Springs case, which was a spring user call against groundwater, A and B, groundwater call, and the Surface Water Coalition call, which is surface water to groundwater. All 3 of those examples, which give pretty much the full range of types of issues that we would expect out of these sampling offer, have gone from the department in 2005 to where we have 2 Supreme Court decisions and we're awaiting the 3rd. So in reality, in about about 7-year period process, we've been able to move through those cases and get some defining law that I think is going to help provide us the framework forward. I think with that, I'll end my remarks and be happy to answer any questions along with Judge Wildman and Justice Strong. Thank you.